Okay. Um, like I said, we have a lot to cover today. So let me just kind of work through how the conversation is going to go, where we've been, and where we're going. So those of you who joined us last time, we shared some stories um, talking about the expected and unexpected. We're going to kind of keep on that theme, but really a couple stories and some context last time to kind of give you some high level things to hopefully motivate you to start the process of looking into a succession plan. Today, we're going to talk about carrier succession examples. I'm going to provide 3 examples, kind of going from the easiest to the most difficult. And like most things, everything happens usually between those 2 things. So I'll give you some examples and some details there. We're also going to talk about a succession planning checklist. So I've developed a checklist for everybody to use, and this is just to kind of get your creative juices flowing, to make sure that things that you may or may not have considered make it into your consideration, and provides a good way to kind of take a nice big first step into what you might want your succession plan to look like. Then we're going to talk about the actual asset purchase checklist. This is a checklist. Again, we're going to just cover some highlights, but there's a pretty in-depth checklist that you can actually use to go through what things you might want to have part of an asset purchase agreement. And again, everybody's scenario is different, and we'll talk about some of those. Some of the things that are on the checklist may apply, some may not apply, but again, it's meant to be have a wide range and a wide reach, so you can kind of narrow it down for your specific needs. We're then going to talk about an agreement that's called a buy, sell, and guardian agreement, and why that might be something you want to look at and consider. It's not the thing that does everything for everybody, but we found it to be a great way to sometimes bridge the gap and give everybody some opportunities on both ends from a buyer and seller standpoint. And sometimes it's one of those things that makes you sleep easier at night. And then, like I said, I've created a resource, agentretire.com. It's just a landing page that I've created. This is where we're going to start putting a lot of the content. The first YouTube video with Diane Roten is on there now. We're recording this, and I'll put this on there as well, so this conversation can be returned to and looked at if needs be. And again, we're going to go from the most easy carrier to the most difficult in our experience. I'm sure there are others, and the rest of the carriers kind of fall in between. So our good friends at Select Health have what I consider the easiest, most straightforward, friendly succession process in place. And here's what's entailed. You or the person purchasing the block of business sends an email to Select Health. You send a copy of a purchase agreement. Many times when we send that purchase agreement out, we redact, the purchase price and some of those details that they don't need, but at least they have the signed copy of the purchase agreement, so they know it's real and both parties have signed it. There's usually an exhibit with all the policy details. Think of that as a list of all the Select Health policies that are going to be transferred to a different agent or entity. And my experience is a maximum of 2 commission cycles take place until that's complete. The majority of the time, that's 1 commission cycle, and you'll see that all those new policies have then been added to your current block of business. And one thing I really like and appreciate about Select Health is there's no maximum of a successor transfer. And what that means is if I sell my block to Nancy Harris, and then Nancy sells it to Doug Draper, and then Doug Draper sells it to Greg Gill, each one of those is what's called a successor transfer. And to my knowledge, Select Health does not have a limitation on that. So very easy, very straightforward, and honestly, it's what should be done to make all of our lives easy, to make sure that our clients don't have a disruption in service or questions, et cetera, et cetera. So in the middle of the road, we have our good friends, UnitedHealthcare. Now, UnitedHealthcare, some of you know, but most of you don't know, has a time commitment in their appointment that's all been signed by an agent that says, and this is verbatim, UnitedHealthcare will allow an eligible successor agent to take over a book of business when we are notified within 60 days of death and the agreement is completed within 90 days of death. So if there's an unexpected circumstance, death, you have 60 days to notify UnitedHealthcare, and it has to be completed within 90 days. And I kind of made reference to this a little bit last time. I've had a number of opportunities to talk with a bunch of you from our last conversation, and I said this to many of you. And this is just something you just need to be aware of. It's not a deal breaker, but it does put a lot of stress and many times some complication on the family or the beneficiaries of somebody who's just passed away. And so it's just something that needs to be looked at and noted and worked on should something unexpected happen. And so it's kind of a bummer because, that's not one of those things that you're really concentrated on when somebody passes, but it's a stipulation within the contract. Now, I do need to say that Stonehill has received a number of exceptions from UnitedHealthcare when we haven't been able to meet that 60 or 90 days. They have been good about it, but they don't have to guarantee that exception. And so we do as much as we can to stay within those parameters. So the process with UnitedHealthcare is you submit a successor agent program interest form that has to be approved by UnitedHealthcare. That form is easily accessed. You can access that through Jarvis, and it actually helps fill that form out to you. UnitedHealthcare has up to 30 days to look at that interest form and approve or disapprove it. In all of the experiences we've had, they've always approved that, but they do not have to approve it. And if there's any question with regard to the agent, some debt, or anything like that with UnitedHealthcare, I have heard from good sources that they do not approve those. So keep your nose clean, and those will be approved. After or when that comes back, or with that, you have to send a copy of the purchase agreement and the exhibit with the policy details, just like you do with Select Health, which are all the policies that you're trying to transfer. If approved from that interest form, they open a 10-day window to complete the successor agent agreement. And that's an agreement that's signed by both parties, which gives legal authority to UnitedHealthcare to actually transfer the block of business to the successor agent. One thing of note in that successor agent agreement is that the successor agent is not eligible to transfer that book of business to another successor agent. So like we just talked about with Select Health, if that's the case and I sell my book to Nancy Harris cannot, per the agreement, have Doug Draper be the successor agent for my block of business. Now, she can for her block, but if there's a block of business that has come to me from a successor agreement, that can only be done once. So that's something to remember, consider, and we'll talk a little bit more about that when it comes to having business in an individual or agent name directly or an entity, because that actually matters in this case. And it can take up to 10 commission cycles until that block of business is fully transferred. Now, don't think 10 commission cycles is 10 months. As many of you know, UnitedHealthcare pays multiple times, commissions cycles multiple times a month. But we found that on average, it takes about 10, which is 2.5, sometimes 3 months until all those new clients have come over from that successor agreement. And last but not least is example 3, alignment, company out of California. This is their process. You have to submit a sales agreement or a bill of sale, a separate list of policies involved in the block of business transfer, which include the member name, effective date, and alignment ID. That has to be very specific, or they will not even move to the next step. You also have to provide copies of CMS-approved member letters notifying the members that their servicing agent has now changed or will be changing. And this is where you reference whether it's because of retirement, death, et cetera, et cetera. The letters have to be approved by alignment prior to sending them to the members. And then you have to show proof of the member letters being sent, along with the proof of postage being paid. They do that mainly with a spreadsheet when you provide them member names, addresses, and then the total cost of postage at the bottom. So it's kind of a pain in the neck. You have to get all of that done before they actually start on the transfer process. Luckily, I've only have had the privilege to do this once so far, but I'm still waiting to have that completed block of business transfer completed. And it's been just over 6 months, and it still has not been done yet, even though we complied with all the other bullet points, provided proof of the letters, postage, et cetera, et cetera. So in my opinion, and in our experience so far, that has been the most difficult carrier to carry out the succession plan with. So hopefully that gives you a little bit of an idea of the different carriers and sometimes why it matters. I've talked to you, some of you individually, about how you have your business and which carriers you have your business with. And again, this is just something to think about and consider as you continue to build your block of business and what carriers you use, because at the end of the day, if you do have an exit strategy or a succession plan you want to execute, sometimes the carriers that you actually are writing with matter. And so anyway, that's something to consider. Let's move to bullet point number 2, which is succession planning, a 10-step checklist. So let me just say, this is not intended to be exhaustive, only helpful, a place to begin grasping a larger picture of questions that you need to consider as you think and or plan for succession. Remember, there's not a right way or an only way to structure a succession plan. This is your block of business. You know your clients. You know the legacy you want to leave, but just make sure your succession plan is the way you want it to be. It's recommended. Our recommendation is always to get professional advice from a well-qualified attorney, CPA, or tax expert. So although we have a lot of experience in doing these, I am not a CPA. I am not a board-certified attorney. And so we recommend that, all the things we talk about are going to be things to consider, and we're going to add to ultimately a great agreement. But those agreements really do need to be looked at by a qualified professional. Okay, so this 10-check step list, again, I'll have links to this, the whole thing. You can download it, you can print it, you can go over it one by one. But I just want to hit on a number of items that typically have questions around them. And if we need to talk more about these towards the end of the presentation, we certainly can. But the first step, obviously, is to establish your goal and objective. And the first thing is just to identify the need of a succession plan. And that's really what I was trying to help develop in our first one, to just get this on the radar and give you some examples as to why you do need to look in and start the process of a succession plan. And then part of that is to develop the vision, the goal, and objective of the business. Again, this is your business. You have a legacy, and I think you deserve to have that legacy continue. and you have a say in what that legacy is. One thing that I've talked to many of you about is family going to be involved in the leadership or ownership of the agency, the company, and is that something you're going to consider? Some of you I've talked to, that the answer is absolutely yes. Some is absolutely no, and some are like, I don't know, I hope so. But those are things that you really need to think about as you kind of figure out what's going to happen, whether it's expected or unexpected. And then really to establish a team of professionals, attorneys, CPAs, bankers, financial advisors, etc., to give you the great advice to make sure that this all comes together. The second thing is who's going to be involved in the decision making. My best recommendation is to involve family members, spouse, family, people you're close with in the decision making process, so they have a voice, but most importantly, so they have an understanding. Again, so should something unexpected happen, they know where things are going and they know the wishes of those decisions. Another thing that sounds something you don't want to really think about, but you really should, is a method for dispute resolution, especially if you're going to have family involvement in the leadership or ownership. How do you resolve those disputes that sometimes you don't think are going to come up, but when something does happen and the rubber meets the road, as they speak, disputes many times do come up. And then to start the process of putting that succession plan in writing. 3 are successors. First, identify those successors, provide the necessary training to those, and ensure that the future of the business is going in the direction you want it to go. Again, if you have an agency and you have some leadership that's actually going to be that successor, or in the case of a family, that family member or family members are successors, but you're giving them the direction, the training to make sure that the agency or the block of business that you've worked hard to develop is going to continue to grow in the right direction. And then the other thing to think about is the retiring owner. Are they going to remain involved or not? Many times that changes. So defining that role and level of involvement is really important for both parties. Many of these things are going to have an estate planning attribute, and so you really need to start looking at the taxation implications on the sale or transfer of ownership of the block of business. A question: does your estate have enough liquidity to pay for estate taxes, if applicable? Many of us, I think, would love if our blocks of businesses were so big that it was guaranteed to have an estate tax problem. Many of them aren't, but it's a question you just need to look at with your CPA or tax professional, just to make sure that you are under some of those guidelines. And have you considered a buy-sell agreement? Buy-sell agreements are part of the process, as we'll discuss a little bit later, but it's a great place to start thinking about how you would maybe want that structured. Consider the transfer methods and corporate structure. Again, strategies and implications from a tax standpoint, legal implications, and the business structure, whether that's proprietorship, corporation, sole proprietorship, etc. Sometimes that's already in place, other times that's not. It needs to be put in place. Again, leaning on a good attorney to actually help with that is going to pay big dividends, and is going to give you a benefit from that point forward. It's hard to go back and do that after the case. Number 6 is contingency planning, which is, again, that dispute or conflict resolution, but developing the mechanisms and addressing those in business agreements. And so it's nice to have a gentleman's or gentleman's agreement that you say, yep, I'll do that, you do that, and then somebody else is involved, a family member or something, and they weren't privy to the gentleman's agreement or the verbal agreement, And so put those things down in writing really makes a lot of sense. I think also developing what-if scenarios, including action plans. A lot of this has something to do with disability. So a lot of times we look at this as expected and unexpected, but what happens if there's something in the middle, right? It's not a death, but it's not an exit on your own terms, on your own timelines because of disability or a medical issue. And so, think about those things. And what if something happens? And is there something in the middle that should be considered? And, again, do you have a plan in the case you become permanently disabled? Something, again, it's not fun to think about, but a little bit of thought makes that possibility much easier to navigate. Business valuation, we'll talk about that next time, but really spending some time determining the fair market value. And then coming down to the exit strategy is what that method of transfer is. We'll talk a little bit about this today, a little bit about that next time, about an asset or an entity transfer. Are you transferring everything? Are you going to hold some things? Or you're selling some of your block of business and not others? We have a number of agents that want to sell certain aspects, let's say under 65 individuals and all their small group and large group employer cases, but they want to stay involved in Medicare, say. What are those things? Establishing a timeline for the implementation, which we'll talk about more next time. Publishing the plan so that everybody has, all the individuals affected are aware of your wishes. And then communicate regularly with those. If things change or there's a modification or something that needs to be looked at or considered, that you regularly communicate with those parties. From an implementation and follow-up perspective, that you've developed a timetable. Make sure that's being planned, and the timetable could be meet with our attorneys to discuss the entity, talk to our tax advisor to just discuss taxation, and really come up with a timetable to make sure that you are accomplishing all the things you need to accomplish, and not just putting them off to one day. Oh yeah, next time we do our taxes, maybe I'll ask a couple questions, and then review the plan on a regular basis and update it as necessary. Last but not least on the 10-step checklist is document maintenance. And this is really, really important. Make sure at a minimum that you have the following current documents in a file: your will, power of attorney, property deeds, leases, rental agreements, etc., mortgage, notes payable, tax returns, financial records, bank, brokerage, savings, and retirement account information. Those of you who have a trust, your trust, a contact listing all of your professional service advisors. So these would be, your attorneys, your tax professionals, etc., and that information. The last two, I think, are really important. Most people don't do this, but it makes the process of succession planning so much easier. And that's a listing of licensing, carrier appointments, and agreements. If your business is with Stonehill, we have all of that for you. And then a listing of up-to-date URL, username, and passwords for carrier and commission information. Because if there is something that happens that's unexpected and service needs to be rendered to clients, agreements are in place, but you can't gain access to some of the carrier and commission information, that actually stalls a lot of things out. And like we just talked about with UnitedHealthcare, there's a 60-day window to start the process, and the process has to be complete by 90 days. And so all of these things help in the speed that those things can be taken care of. So that's the 10-step checklist. Again, I'll provide links to it so you can actually print it out and look at it, but that's some of the things that you'll see on that checklist. Now, let's talk about the asset purchase agreement. So this is, again, not to be exhaustive. It's a helpful place to begin. Some of the items that you should consider through designing and drafting a purchase agreement. Again, there's no not right way or wrong way or only way. So just think of it. Make sure you think of that. Again, it's your business. You should have a say in what's happened. And as always, we recommend you get the advice of a tax expert, a qualified attorney, et cetera, et cetera. Okay, so in an agreement, there are a number of agreements that may be part of an overall asset purchase agreement. Many times there's a letter of intent, and the letter of intent basically says, I am interested and I want to buy your business. And that letter of intent may be binding or not binding. And that's something that you need to consider and define, and have your attorney who's going to help you with that letter of intent usually figure out whether it's going to be binding or non-binding, because there are pros and cons to having it be bound or non-bound. And think of it this way: if I reach out to Nancy Harris and say, here's a letter of intent, it's a binding letter of intent, and all of a sudden the next day the market crashes and interest rates go up by 20 points, and I'm bound by that letter of intent, I have to roll with those punches because it's binding. So there's an upside because it can be bound if it goes in the direction one direction, but it's also I'm bound if it goes in the other. Conversely, if it's non-binding and I ask, say, Nancy, I'm interested in purchasing your thing, let's sign this letter of intent, and then good old Doug Draper comes along and says, Nancy, I'll do you one better. If my letter of intent is non-binding, then Nancy's not bound to first come, first serve. She can basically take whoever she wants, but she may lose, me in the process. So again, something just to kind of consider, something to be aware of when you go down that road. The main contract, of course, is called the Asset Purchase Agreement. This is where everything's contained. This is the agreement that we send to the carriers, and this is the one that contains all the ifs, ands, and buts. But there are other agreements that can accompany that. One is a security agreement, where the seller retains an interest in the asset or other property in the event of a buyer default. And some people like that. An escrow agreement, of course, for how to handle the funds. We've been through that if you've all purchased a home. An employment agreement for when an asset of a company contains key personnel. We've done this personally at Stonehill, great block of business that we purchased years ago, came with an employment agreement for a key person from that agency. And so, we had to define that and what that was going to be. Non-competition agreement is really important, and this will come back in an example I'm going to give you towards the end. And a non-competition agreement usually has a term to it. Some people say a year, 2, 3, up to 5, but you'll see why that might be important a little bit later. And then a non-disclosure or confidentiality agreement is usually part of an overall asset purchase agreement. So you can see that there are a number of items that can go into an asset purchase agreement, and some of which might need to be separate from the asset purchase agreement. But just so you're aware that those are some of the agreements that you should be aware of. 2, exhibits to the asset purchase. Exhibits, of course, are things that are going to be part of the agreement, but they're going to be listed separately. Usually towards the end of the agreement, Exhibit A or Exhibit 1. B, you can have as many as you want as long as they're listed correctly within the overall main agreement. Some of the things to be named in exhibits are assumed business names, trade names, and internet domains. A list of employees and independent contractors. These could be sub-agents involved in a business acquisition. So if you have an agency and have a number of downline sub-agents, that list is important. A list of customers, clients, referrals, and other trade secrets, if there are any. Licensing carrier appointments and agreements. Again, depending on who your upline is, that can be provided for you. Again, one of the things that we looked at from a succession planning checklist standpoint are URL, username, and passwords. That is extremely valuable. Disclosure of any encumbrances on the asset, which needs to be disclosed. Other statements to verify applicable regulatory compliance if needs be, and any insurance policies that might be part of the asset purchase. So those are usually listed separately as exhibits. So just a couple of those things to consider if some of those things are things that actually you have in your business. Financial statements. So balance sheets, income statements, P&L statements, accounts receivable, tax returns showing the tax clearance with the IRS are all really important. I'm sure all of you have good accounting and tax people. That would be easily done. If you don't, I highly recommend that you get that part of your house in order, because that makes a big difference when it comes time to look at valuation. The other thing I think is really important and gains some real insight to valuation overall of what your block of business is worth is the past 12 months of commission statements by carrier. An easy way to look at valuation is taking that 12 months of commission and putting a multiple on that, whether it's 1 or 2 or 3 or whatever the case may be. And that gives you an overall starting point for what the value of your business might be worth. So having all of that in a organized manner is very valuable. And then bank deposit statements showing the amounts by carrier, those carrier deposits for 6 months. And this is just another way to actually show and verify that the commissions by carriers are actually being deposited, and the deposits actually line up with the commission statements. And so, again, just nice things to have all tidied together and organized. Organizational documents could include articles of incorporation and an operating agreement. For those of you who have an LLC, I hope most of you have an operating agreement. If you don't, I highly suggest that you have an operating agreement in place. And when any change to an operating agreement or any articles of incorporation, those amendments or addendums actually should be part of those organizational documents. Because whoever's going to purchase that entity, whether it's the asset or the entity itself, really needs to understand what the operating agreement is, what changes have been made, and why. That goes for bylaws as well, and a list of all shareholders and the shares they own. Shares, of course, are part of S and C corps, and so those need to be disclosed if you have one of those entities. Sometimes a certificate of good standing is recommended or required from the state, saying that you've kept your entity in good standing and that there aren't any encumbrances or other things listed there. And a list of any law, accounting, or consulting firms that you have retained. You'll kind of see that throughout the course of all these documents. Number 5. So important terms and dates for the transaction, just things to know about. Some of these, again, can be combined into 1 or 2 items sometimes, and it depends on the business, what is being purchased. Some of these apply to all of those. And that is the purchase price of the asset, of course, the due diligence period, or the period that you're going to gather all the information, share that information with each other. The escrow date, we've talked about escrow, a closing date, so we can all kind of have a good idea of when things should come to an end. And then any post-closing items. And post-closing items could be, transference of office space, of employees, all those things that come after a closing date, but need to be addressed sometimes separately. And then accounting and tax items. Again, one reason you need a good tax person is there's a form IRS 8594. If you have an asset acquisition, this is the IRS's asset acquisition statement. needs to be sent in and filed both by the buyer and seller. IRS 8822B is an EIN change. So if you are buying or purchasing an entity, the IRS needs to know that that EIN number has had a change in responsible party, the location has changed, and the address has been updated. And then again, understand the tax consequences and get help from a CPA or tax expert. And on that point, tax consequences, let me just share with you an idea that you may want to consider, because we're both going to be in a position of maybe selling businesses or acquiring businesses. And if you don't really get some good help, you might be stuck with something like this. So if there's a transaction between a buyer and a seller, and the asset purchase, the block of business asset purchase is done, and this is for illustrative purposes only, the tax burden for the buyer is usually deductible, and the seller has to pick up that income as ordinary income. And that obviously is a benefit for the buyer, and the seller, of course, has to, take that, and sometimes that's, doesn't seem very fair. Well, there's other ways to do it. And again, this is just for illustrative purposes only. And this is something that you might also want to consider. And so instead of 100% of the earnout or asset purchase, we're, under this scenario, we can actually separate it out into virtually a 50-50 deal. So the buyer and seller actually get some tax benefit. And as you'll see, the buyer and seller, they still, on the earnout, it's still deductible or taxed as ordinary income, but that's only for 50% of the transaction. Remember, we talked about that non-compete agreement, how it could be 1, 3, 5 years, or whatever the case may be. Well, a good CPA or tax expert will actually look at that depreciate or that non-compete term, and under a certain IRS statute and code can actually make that depreciable per that term. So if it's a 5-year non-compete term, long-term capital gains can be extended to the seller, and a depreciable part of that can be actually on that non-compete term. Same thing with a blue sky. Typically has a up to 15-year depreciation schedule. And then the seller, of course, has that better treatment of long-term capital gains instead of ordinary income. So again, just a snapshot. It's not meant to say this is what you should do, but just to make sure that whether you're the buyer or the seller, that you know that it's not just one way, that there are ways to actually do things that are fair for both the buyer and the seller. Okay, moving right along. Let's talk about planning for the what-ifs. We'll talk a lot about expected and unexpected. And this is an agreement that is something to consider. It's not something that you have to do, but I get asked the question quite a lot. Is there something that I can do that protects me from unexpected things, but also gives me flexibility on things that may be expected? And the answer is yes, you can do this in a number of ways. One of the things that we use and I like is called a buy, sell, and guardian agreement. Again, it's not meant to be exhaustive. This is just only to be helpful and a place to start, and to make sure that one of these guardian agreements, and I'll provide you a template. You can take this to your well-adjusted attorney to make changes, because my experience is anything you take to an attorney, they're going to actually want to fiddle with it to make it their own, which is great. But this provides a template as maybe a place to start. But what a buy, sell, and guardian agreement does is it provides the first offer right to purchase assets. What that means is, there's a pro and a con to this, right? So if I enter into a buy, sell, and guardian agreement with Nancy Harris to purchase her block of business, basically what I'm saying is, Nancy, I want the first right to give you the first offer to purchase those assets. And so whether you're going to, it's unexpected and you want to retire, you're going to grant me that right. And for that consideration, I'm going to actually give you some things to see if something unexpected happens, that I'll guarantee that I'm going to purchase that block of business. And so that's something you need to consider, because, it's not a one-sided agreement. This is a two-sided agreement. But what it also does is it provides guardianship for managing clients, accounts, etc., in case of an unexpected event. So in this case with Nancy, what would happen is I would also be entitled to a guardianship part of the agreement. So I could continue to manage Nancy's business while her family, heirs, and etc. are dealing with some of those unexpected events, knowing that the business isn't going to fail, it's not going to close, clients are going to be serviced, etc., etc. But that's specifically set in there. It also provides definitions for a purchase agreement. And we just went over some of those things that you need to consider for a purchase agreement, and this defines some of those. One of the things I love about this agreement is it includes the acknowledgement of the spouse, if applicable, and or other parties. And so it's not one of those things that's going to catch anybody by surprise, but it has the approval and the acknowledgement and the signature of the person who's really going to be left in managing that block of business should something unexpected happen. It also defines and lays out an agreed value. And so again, if we go back and remember what Diane wrote and said about how it was just the most terrible thing she'd ever had to do is to deal with Dennis's business. She didn't have any idea what to do, what it was worth, all that kind of stuff. If something like this was in place, the guardianship would have made sure that his business continued to function. There would already have been an agreed value between the parties about what it was worth. The purchase agreement would have been defined. And last but not least, it includes an executable buy-sell agreement. So if she just wants to say, you know what, this is great, thank you, I've mourned the loss of my husband, and here's all the paperwork that needs to be done to actually transfer that business to the other party, that's included as well. So again, it's a great place to start. And it's something, again, that I get asked a lot is there something that kind of can do both things? This can do both things. And so what it does is it provides the security, the confidence, and the ease of freeing up that burden of what's going to happen if something unexpected happens. But it also allows the person that you're entering into the agreement to say, hey, for some of this, I know that I have some things to do too, which is the guardianship aspect. The purchase agreement has already been agreed to. And so it makes it sometimes easier to sleep easier at night because some of this has already been done. Now, does this mean that if I have one of these in place with Nancy and I decide I don't want to retire yet? In fact, Nancy, my son's getting in the business and I want to actually transfer that to him. Does that mean that I'm bound by this agreement? Well, no, the only thing I'm bound to is to make sure that if I am going to sell the assets, that Nancy has the first offer or the first right to that. Many times, my experience is if Nancy knows that my son's going to be in the business and that's all fine and dandy, then, basically the agreement becomes null and void, and it can be transferred to my wishes, but both parties have to agree to that. So, but again, I'll give you a template of this, show you where that is, and again, just for reference, again, not to be exhaustive, but as a place to start with your tax or attorney professional. Okay, here is the resource that I've created and I'll show you what that looks like here in just a minute. agentretire.com. This is a Stonehill page that I've created There's some things listed on the top, but if you scroll down towards the bottom, you'll see the video of Diane Roten of our conversation last time. I'll also post this series, part 2, in there as a YouTube video, so you can come at that again. And then the documents that we talked about today are all listed there, so you can download those, look at those, modify those, do whatever you need to do. So that's agentretire.com. This is what it looks like towards the bottom. So you can see there's Diane, her YouTube video. Underneath that, you'll see what this looks like as I kind of convert that to YouTube and do some editing there. And then at the very bottom, you'll see some sample documents. So there's that Succession 10-step checklist. You can download that. There's the asset purchase agreement checklist. You can download that and print that off. And then there's that sample agreement of the buy-sell guardian agreement there, and you can download that. I've put the buy-sell and guardian agreement template in Word format, so that makes it easy to edit, easy to take to an attorney or whatever, and again, a great starting point. Not that that's the only way to do it, just it's one way to actually start that process. But that's what the page looks like, and you'll see that the documents will expand, especially after our next conversation, and the videos that we're doing in this series will be linked all there for future reference.